Okay, hi everyone. I'm Jonathan Liberman. I'm an Associate Professor in Law and Global Health at the University of Melbourne, with a joint appointment across the Melbourne Law School and the School of Population and Global Health. Welcome to Melbourne Law School's live webinar series, Law in the Time of COVID-19. The series brings the expertise of Melbourne Law School scholars and associates to bear on the legal dimensions of the extraordinary health, economic and social crisis in which we find ourselves. I'll turn to introduce our panellists and the topic for the day in a moment, but first, today we're meeting on the lands of traditional custodians, whether that's in Melbourne, Victoria, Australia or overseas, and we pay our respects to their elders past and present, and I especially extend my acknowledgement to any Aboriginal and Torres Strait Islander people who are joining us today. Let me also acknowledge and welcome our academic community, alumni, students and friends of the law school. It's wonderful to have the Melbourne Law School community come together at this difficult time. The title of today's webinar is Privacy Post-Pandemic, Restart or Reset. COVID-19 has posed a number of deeply challenging questions about the boundaries between what we have traditionally regarded as our private spheres and what about us and our lives is of interest and importance to others in our communities and to our governments. At one level, the relationship between the private and what I'll call for now the non-private, because it's not necessarily the public, inevitably comes into sharp focus simply by virtue of novel coronavirus 2019 having been declared a notifiable condition or a similar expression in different jurisdictions, which means that each case must be notified to public health authorities, triggering a whole host of consequences, including a legal requirement to self-isolate for the person diagnosed until allowed out of isolation by government health authorities, and to self-quarantine in the case of people who reside with the diagnosed person and other close contacts. And as we've come to see over these last couple of months, the questions about the boundaries between the private and the non-private are presenting in many different contexts in many different ways, many of which we feel we are grappling with for the first time and we don't necessarily have immediate answers for. So to help us work through what's going on and navigate our way through these challenges, we have a stellar panel of experts with us today. Richardson is a professor at Melbourne Law School and one of Australia's leading privacy law academics. Megan has held numerous roles advising on significant law reform projects in Australia, and her work has long been recognised globally. Megan's recent books include The Right to Privacy, Origins and Influence of a 19th Century Idea, and she has a new advanced introduction to privacy law coming out later this year. Welcome, Megan. And I don't know if you heard my dog just welcomed you as well then. Jeannie Paterson is a professor at Melbourne Law School. Jeannie's work focuses on consumer protection and new technologies, and she's the co-director of the University of Melbourne's new Centre for Artificial Intelligence and Digital Ethics. Welcome, Jeannie. Mark Taylor is Associate Professor in Health Law and Regulation, Melbourne Law School. Mark is interested in health data governance, privacy and the public interest. Mark is Deputy Director of Helix, which is a research group looking at the intersection of health, law and emerging technology. Welcome, Mark. And finally, Stacey Steele is an Associate Professor at Melbourne Law School. Stacey is both an academic and a lawyer with extensive experience in financial services across the Asia Pacific. In addition to her academic work, Stacey is Deputy Chief Privacy Officer of a multinational company with over 20,000 employees operating in 30 plus countries. So just before we get into the event, a few housekeeping matters. The event is live and is being recorded. Parts of it may be published later, and the event will go for around an hour. We'll start by me moderating a discussion between our panellists, which will initially go for about 30 minutes. We've got a lot of material to get through, and I am happy to say I have the permission of our panellists to be a ruthless moderator if needed, and no one will be offended if I ask them to wind up. So can indicate agreement with these rules by thumbs up. Very good. And we want it to be as interactive as possible. So you may see hands going up during the session. We encourage our participants to submit questions using the Q&A function that you should be able to see. We'll be moderating and collating your questions, and after the initial discussion, we'll be putting your questions to panelists as time allows. Okay, so let's go to Megan Richardson first. Let's start with a couple of the big questions. What do private life and privacy mean during a pandemic? And if you try to think back to the distant past, let's say the 29th of January this year, the day before the Director General of WHO declared COVID-19 to be a public health emergency of international concern, how were you thinking about privacy then compared to today, and has anything fundamentally changed?
Oh, thanks, Jonathan. Those are really good questions and so much to say, but I'm going to try to keep to time and just hint at a few of the ideas that I've been thinking about over the last few weeks, months, years. So I would just say in summary that yes, in many ways, as so often, there have been some major shifts, and I expect more there will be in the future, but there are also continuities as well. For instance, this question of what privacy means now and what it meant before, what it might come to mean. And already we know that there could be more than one meaning of privacy. We've been talking about that for a long time, what these privacy scholars have. In one sense, for instance, privacy is understood as meaning control over personal information or data. That's been the subject of much public discussion in recent years. For instance, the Snowden revelations, the Cambridge Analytica scandal, the current kinds of debates about the COVID Safe app, for instance. And I think you've alluded to this already in your introductory remarks, Jonathan. There's another more traditional sense of privacy as about private life, a kind of intimate sphere, family sphere, domestic sphere, or a sphere that you might share with particular chosen friends and alliances. And that kind of sense of private life, I think, is also important. It's also there. And it may be less talked about in public discourse, but it comes through very strongly when you drill down and you talk more closely about these issues with people. And that dualism, I think, has been there in the past, and it's still there in the present, and I imagine it's going to go through to the future as well. So, for instance, at the moment, we're seeing great concerns about surveillance for public health reasons, and then again, at the same time, more at homeness that you've been talking about, Jonathan, being at home, being kept at home for various reasons, again for public health reasons predominantly. So on the one hand, we're thinking about how is our information going to be looked after with the COVID Safe app, for instance, just one example. Or on the other hand, we're also experiencing this being thrown back on private life in a much more intense way than maybe we haven't experienced recently. And it's not just about being more focused on our physical homes with those who are in our homes with us, but also keeping up our networks with our family, friends, and others, and those that we're trying to link with online and keep in touch with. And so in the past, there's been this discussion around network privacy. I like that language. But I think also it's really about privacy at a distance when you're thinking about the physical dimensions. And of course, there's another way in which things are changing as well here, that private and public life have often been talked about as being interconnected. Or, well, I think that we're seeing that more and more now. For instance, the fact that I'm sitting here in my house with all my personal things around me and then talking to you and to others, to everyone here at the seminar, in a work seminar, essentially. So, and I think this will keep on going. So just to wrap this up, because I know there's lots more to be discussed in this seminar, I'm hoping there will be at least some good things that will come out of the situation we're in. For instance, that private life will be more openly valued. Not that it hasn't been valued in the past, but it will. I'm hoping it will be something we're more consciously thinking about as a valuable addition to our lives. And that might, as a lawyer, I'm hoping that will feed into law, for instance, discussions about how the law should be framed, both in terms of private law and also in terms of constitutional law, and thinking about privacy in this kind of multifaceted sense, as including not just control of personal information, important as that is, really important, but also about maintaining a private life maintaining the boundaries that we want to draw around our private life and being able to have or rely on the law to support us in that. And at the same time, thinking of private life not just in a negative sense of an area of life that's secluded from public lays, but as a positive area of human flourishing, of small community of intimacy. And I like to imagine that's what the framers of the Universal Declaration of Human Rights had in mind when they included the right to privacy, family, home, and correspondence in Article 12 of the Declaration in 1948, coming out of World War II and thinking about how to build a better world.
Thanks, Megan. Does anyone want to jump in on that general question at this stage? Jeannie.
I'd just like to make some comments. I agree with all of Megan's insights and the importance of the private space, the home. I think that it's obvious, and we're all aware that for the private space is not helpful, is not a safe space for everybody. And I guess the flip side of COVID-19 has been a growing awareness of people who are not safe at home or don't have homes that they can work in or comfortably live in. So there's an equity issue that hopefully COVID-19 will prompt us to think about, and a safety issue in terms of physical safety and security in the home, which simply isn't available for everybody.
Stacey?
I think that perhaps I started thinking about this really when the My Health Record debate came in Australia in sort of a health personal context, do I want to be part of that, etc. But I'm also old enough to remember the Australia Card debate, and then the debates we had around anti-terrorism after September 11, and the intrusions we now have as part of our legislative framework from those events in the past. And I think Megan's point there about our privacy, though, in terms of how it's understood in the home, is perhaps the defining difference in terms of what we're experiencing now compared to some of those events previously. And even from my perspective, now being more new to this space than our other respondents today, my privacy isn't private anymore. People are asking me, have you downloaded the app? And, if you haven't downloaded the app, are you un-Australian? And so suddenly privacy is going into all these other parts of, I think, people's conception of themselves and what's going on. But I do think for mine, it's been sort of an evolution of thinking. I don't know that COVID-19 has drastically changed the way I think about privacy, but I think there's lots of other things that are coming out in this scenario that are much more nuanced than perhaps we hadn't thought about previously.
Thanks, Stacey. And Megan and I were having a chat about something the Victorian Chief Health Officer said last week. So it was at the media conference where Victorian government was announcing that some of the restrictions were going to be eased, and the Victorian Chief Health Officer was asked about handshakes and hugs. So would he be shaking hands and hugging people who he was now going to be able to see? And he was very careful in the way that he answered it. And he said that while he wouldn't be shaking hands or hugging people, he understands it's important to other people. And he said, and I wrote this down at the time, he said, I'm not going to step into their private life, which really struck me, because this is I'm not trying to criticize him, but it was at the same media conference where the announcement had been made that we would be allowed to have 5 people in our home. And for some reason, those other restrictions weren't regarded at all as stepping into our private lives, but there was something about shaking hands and hugging. So Megan, thoughts on how we see privacy, what is a matter of privacy and what's not?
Yes, thanks, Jonathan. And Stacey, I think you've been touching on that as well. Like being told to be private in certain ways, is that makes you really think about what privacy means and the value of privacy. So yes, it's absolutely right that privacy scholars do tend to think of privacy as a dignitarian and liberal value, that it's about choice, it's about our preferences and who we are and asserting our identity here. But that becomes so much more complicated when we're told by some authority figure what is private and what is not, and how we are supposed to treat our private life as well. And I think coming back to Jeannie's point, that's an absolutely fair comment, that not all of us have the safety of being in the home, or even have the home to be safe in, and that so how does that all fit together? We're starting to think much more intensely about a whole range of things, and when we get into a situation where we have little control over even what's our private life and where we spend our private life, then will we stop thinking it's so valuable in the end? That's something I do start to wonder about. I think partly it depends on the circumstances. We might tolerate more if we're told that we're being told to do, if we trust the reasons for it. And if it's temporary, I mean, I think if it's permanent, it'll be a much greater concern.
So maybe segueing, you've mentioned trust there. So over to Mark Taylor. Mark, much of your work is essentially about the relationships between privacy and health. So can you tell us, how do you see those relationships? What's COVID-19 telling us about them? Is there anything fundamentally new or different that's happening here?
Jonathan, well, I think privacy is critical to health. I think there's a really important relationship between them. I think back to when I was chair of a national committee which advised on access to confidential information without patient consent for various medical purposes. We held a public event, and at the end of that event, an elderly lady came up to me and she took me to one side and she told me about something that happened to her as a child that was recorded only in her GP record. She hadn't shared it with anyone else her entire life, except she told me then and there, because she wanted me to understand what it would mean for her to somebody else to have access to that GP record. We routinely share our most intimate details with our healthcare professionals because we trust that they're only going to use that information for the purposes that we expect. So for me, I mean, Megan's absolutely right, of course. Privacy is, understood in many different ways. It's been articulated in many different ways in the literature. But for me, one of the most significant ways in which it's articulated, one that resonates with my own work, relates to the notion of a reasonable expectation. Privacy is the protection of a reasonable expectation. And if you view it that way, privacy actually enables us to disclose. It enables us to disclose those details to a healthcare professional because it prevents the misuse. It prevents the uses that we don't want. It enables us to use it in the ways in which we do. And often that is about trade-off. So you asked me about how has COVID-19 changed the picture? Well, in some ways it's changed it fundamentally. In some ways it's changed it not a jot. So what we consider at the moment to be an acceptable trade-off between a privacy intrusion, a kind of constraints upon private life, liberty of movement and all those things, what we consider to be a reasonable trade-off between privacy intrusion and the public interest needs of a public health emergency, it's radically shifted, as we all know. But how do you justify that? That hasn't changed. So an understanding of what's necessary in order for that trade-off to be acceptable hasn't changed at all. You still need to be able to demonstrate value. You need to be able to demonstrate the value proposition in the trade-off so that people recognise that it's actually in pursuit of an end which they themselves value, and the trade-off is one which is fair. You've got to be able to demonstrate security so that the data is only going to be used in ways that people accept is appropriate. People worry about creep, they worry about data creep, they worry about function creep, they worry about misuse by both authorised and unauthorised parties. You've got to worry about accountability. Is the decision making robust? Is it a well-founded, avoiding capricious, unreasonable decision making? Is it open to independent review? And in relation to all these things, you've got to have transparency so that all of those things are clear. And although in the immediate crisis, our understanding of what is a reasonable expectation in relation to those things may change, it's not a permanent thing. Privacy is contextual, and it will shift again as what is considered to be necessary and proportionate as interference changes.
And can you, going back to the example you started with, the elderly lady who approached you, so I think perhaps if you can say a bit more about what the kinds of things that we're worried about in misuse of our data. So I'll say people like me who aren't at all tech experts worry about something, but I think often don't know what we're really worried about. So do you want to develop that a bit more?
What are we worried about? The worries are sometimes for ourselves, sometimes for others. Sometimes we worry about tangible harms of discrimination, stigmatisation. Sometimes they're ideological worries. We worry about shifts that actually represent a change to a type of world that we just don't want to live in. So many different sorts of worries, but fundamentally it's often about data being used in ways that aren't in our best interests. People taking advantage of and instrumentalising and commodifying us and just using us and our data for ends that we wouldn't recognise to be acceptable and which we don't accept and think fair.
I think you mentioned stigma and discrimination. And I think one of the things I've been wondering is, and it may be premature to know how much discrimination or stigma there will be about COVID-19. I think it's just too early to know. Megan, and then we'll get to Jeannie.
And I suppose I would add to what you're saying, Mark, also manipulate us is another concern. But I mean, I totally agree with everything you're saying. And you've also reminded me of something that I should have said earlier, which is when we talk about private life, it isn't only in the home, it's what we carry around with us about our private sphere, the aspects of ourselves that we consider to be for us.
Okay, over to Jeannie. So much of the public discussion of privacy has been focused on digital contact tracing and particularly apps, in Australia's case, the COVID Safe app. So can you talk us through this? How should we think about these apps and how can we make both public policy decisions and decisions as individuals?
Well, thanks, Jonathan. My background's in consumer protection, so many of the themes that were mentioned by Mark also come up in the consumer protection space, but perhaps just viewed from a slightly different angle. So even with a government initiative, I tend to think about that through a consumer lens. And this would suggest that when we're thinking about, for example, the app that's been promoted by the government, we'd be thinking about whether it protects citizens' rights, interests and expectations, whether it's transparent, whether it relies on genuine or forced consent, and whether it's effective or fit for purpose in what it's doing. Now, if we start with privacy, as Mark has commented, that's not an absolute value. We're constantly thinking about how privacy is balanced against other social objectives and public goods, if you like. There's been debates among technical specialists and privacy experts about the degree to which the app respects privacies and the way it could be better in respecting privacy. And certainly those considerations have informed the design of the app. For example, it doesn't use geolocation, it doesn't track where people have been, it tracks who people have been in contact with. That's a privacy protecting measure that represents somewhat of a trade-off against an epidemiological or health measure, because if we were interested in mapping the spread of COVID, we'd actually be very interested in where people have been, but the decision has been taken not to go that far. It's still, I think, quite difficult to find out good information about how the app works, what sort of information it collects and what will be done with that. We know that we have to upload it and download it, but it's unclear, for example, to many people what information is collected. We've heard that the app is interested in people who've been around for more than 15 minutes and quite close to. In fact, the Bluetooth technology collects information about everybody we've been in contact with who has the app turned on their phone, whether or not they're in the same room with us, whether or not there's a risk of spread, and even very transient interactions. So there's still questions there, I think, about how that sifting of that data takes place and what happens to data that isn't used for the contact tracing purposes. But importantly, I think the app is not mandatory. We're not like, for example, some other countries where it's necessary to have an app to even go out of the house. The app relies on consent processes. And in fact, it's a two-stage consent process. We've got to consent to download the app and keep it switched on. And if we became infected with COVID-19, we'd also have to consent to share our information that is on the app about who we've been in contact with for that contact tracing purpose. And that brings us to that question of fitness for purpose that is integral, I think, to thinking about this trade-off between privacy intruding measures and public health measures and other social goals that we might want to pursue. How effective is the app and what is it actually effective for? So you and me, Jonathan, have had conversations about the name of the app. It's called COVID Safe. It's not a safety measure. It's not a shield. It's not a sunscreen. It's actually about making tracing of who we come in contact with more effective. Often we don't remember where we've been or who we've talked to. The app is a better form of memory prompt in some ways. But the language that's used around it, I think, is really interesting because it suggests something more. It's focusing on keeping us safe or community when the purpose might be quite different. How effective is it in contact tracing? We don't really know yet because it depends on how much of an uptake we get and also how much of an uptake by people who actually do turn the app on it comes about. And here again, I think we have another, we come back to those issues of trust and privacy and indeed transparency. People are more likely to use the app if they feel confident those other measures that Mark has mentioned, transparency, accountability. So if that trust is there about what's being collected and what the information is used for, we're likely to see greater use of the app for those public health benefits. And here I'll leave it, but I'll just note perhaps the messaging around the app has been a little bit mixed. Is it a safety measure? Is it a contact tracing measure? Is it a measure to get us back to work? And is it a measure that may in the future be used to determine who gets access to public spaces as opposed to confined to their private spaces?
So can I just ask you then, so what does it tell us that the Australian government, at least unlike some other governments, has chosen those two aspects, that it's Bluetooth, not geolocation, and that it's not mandatory?
It shows us that the government has been very alive to the privacy implications or the privacy consequences of this app, that we as an Australian community care about privacy, although we could go further in the legal protections that are there. The government's been alive to those considerations by in fact constraining the operation of the app in a narrower way than perhaps we've seen in other countries. But equally, if you listen to what's happening, for example, in the US, we still have a very centralised system. The information collected by the app, if we give consent, if we become infected with COVID-19, is still uploaded to a centralised authority, public health authority, who will then sift and sort that information. And it's interesting, I think, to compare that to what's been proposed in, say, the US, where the talk is of a decentralised app, so that the Bluetooth information that's collected never goes to a centralised authority, and all of the contact tracing happens at the level between users of the app, or users of phones actually, because if engineered by Apple and Google, it will actually be part of the operating system of those phones. So we see different choices about how information is managed. And I think Australia is probably sitting somewhere in the middle of a small group of users of this technology.
Okay, thanks. And Stacey, so as I said in the introduction, you're the Deputy Chief Privacy Officer of a multinational company. You've got a host of insights into the role of the private sector, how it collects and uses information. And so looking at COVID-19, what's expected of the private sector, and how do we work out what should be the role of the private sector and what should be the role of government?
Thanks, Jonathan. I think that it's incredibly difficult to be in a space at the moment trying to help with the community effort and the response to COVID-19 and have all these different layers of regulation and responsibilities. And so there's two things really that's going on. First of all, we are seeing a co-opting of the private sector to help with the response. You know, initially, for example, the government has come out, and Jeannie talking about the app, saying, you know, you're not going to have downloaded the app, and people can't require you to have the app in order to go to a cafe or in order to return to work. And yet we're seeing cafes and restaurants being told by the Chief Health Officer over the weekend that in order to reopen, they're going to have to collect contact details or possibly other information as well. We're not sure yet. And so you don't you don't have to require, you can't require the app, but on the other hand, we're going to require you to collect all this information on our behalf, which maybe you have to keep for a certain period of time in case you have to give to the health authorities for contact tracing. Now, it's kind of understandable that that's what people would want to be done, but by the same token, you've now got a situation where it's a little bit difficult to know, where does the government start? Where does the private sector start? Where do individuals versus individuals start and stop? I mean, as Jeannie explained, it's a Bluetooth adoption of what we've done here with the app. And so suddenly now other people are going to know that they've been in contact with you and that you may have COVID-19 if you've allowed the health authorities to then go contact them as well. And then the second point I'd make is that for some of these private sector actors, putting aside what the centralisation model and what's going on with the app, they're potentially collecting this type of information for the first time, and or it'll be the first time they really had to think too carefully about privacy, because in Australia, if you're a small business with a turnover of under $3 million, the Privacy Act doesn't apply to you unless a certain other threshold requirements kick in. So for a vast majority of our cafes and our restaurants, and even a vast majority of our employers who are small businesses, they've never had to worry about the Privacy Act. And so whilst you might have wanted to protect people's information because that's the right thing to do and it's a reputation issue, it wasn't as though you were necessarily going to breach the legislation. And, you know, just to give you one other example on that second point, some employers are going to be very well prepared for collecting this information. You know, the larger companies, the mining companies who collect other types of fairly sensitive information about their employees. Other employers are not going to be ready for this type of information collection, or information collection about their customers and their clients potentially, especially if we start getting into temperature checks, which means that I think that whole data protection mindset is going to be quite new to them. And that goes back to Mark's comment around trust, because if we don't have data protection adequately dealt with and sorted out, that takes us into a whole other area of people thinking they can trust and then finding out they can't because they've then got a breach. And then flowing from those 2 points, 2 other points for business to think about. First of all, Australia's relatively open class action regime. And we know that plaintiff law firms for a while have been trying to figure out how privacy fits into their business model. And so particularly for large companies, with deeper pockets, that's going to be a prospect that they will be concerned about. And then secondly, for those entities that do fall within the Privacy Act, the new mandatory breach reporting regime is also going to be front of mind, because that comes back to Mark's point about trust. You're actually going to have to tell people if something goes wrong with this information. And so I think we really need a mindset, if you collect it, you protect it.
Thanks, Stacey. Megan, your hand.
Yes, I was just going to say there is some common law protection, so you might have an issue over breach of confidence. There could be liability in various ways, and I know some of the class actions that have already kind of just claims about, say, negligence, and claims that have kind of looked to at least the standards in the statutes, even if they can't be brought directly under the statute, but have also used common law doctrines like breach of confidence. So there's a whole range of legal standards that might suddenly come into play here.
Yeah, so it's really complex and difficult for people who are in the private sector being co-opted into this effort by the government in the response to COVID-19, probably rightly so, but for the first time having to deal with some of these issues that put them in a really tight spot from a liability perspective. They want to do the right thing by their employees. They want to make sure everyone's healthy and safety and secure, their well-being's being looked after. But on the other hand, we have this issue that they need to think about in terms of people's privacy. You know, can I tell people that a person in my building, in my office, has been diagnosed as COVID-19? In fact, do I have an obligation, apart from telling the health authorities, do I have an obligation to tell people about this? Do I name the individual? They're going to be really hard questions, particularly as we transition back to the office, back on public transport, getting out there more. And what is that actually going to mean for these people who are having to make a risk-based decision on these issues? Because in some jurisdictions, you know, if I look at this internationally, Russia, the Moscow authorities are requiring employers to test their employees every 4 hours, and then they have to have 10% of their workforce having had a COVID-19 test at the moment. So we're seeing lots of different jurisdictions approach things differently, but that puts a really big burden on the private sector.
Megan, and then I'm going to go to the first question that's come through from the audience.
I just wanted to add that a lot of the information you're talking about there, Stacey, is health information, and that is subject to quite restrictive regulations, actually.
Yeah, and we should note, obviously, Megan, too, that, you know, to the extent something's within an employment record, that also would typically fall outside the Privacy Act as well. So there's all these little nuances that suddenly people have to work through.
Mark.
It's interesting, though, how far the government felt it needed to go in order to reassure people in relation to the COVID safe app data, and be able to reassure people prospectively about what could and could not be done with that information. Megan, I agree with you entirely that there's a lot of protections there, but some of them, particularly say in relation to the common law duty of confidentiality, you know, you only establish often retrospectively once somebody has successfully brought an action for a breach. So when it comes to giving people clear prospective guidance and guarantees that this is what the data will be used for and this is what it will not be used for, because I often see people with really well-intentioned wanting to use data for good things, and they just don't turn their minds to the misuses which could be made of the data, because that's not what they intend. But because they don't put their head there, they don't protect against it, and then they get a difficult question: well, could this data be used in this particular way? And the answer sometimes is, well, it could, but we don't intend to use it that way. Well, that's not good enough. We need to be able to give people the kind of upfront prospective assurances in relation to the data which has been collected outside of the COVID Safe app that the government has sought to try and provide in that particular context.
So just before we go to the first question, so I'm just reflecting on our discussion and thinking about the sheer complexity of the issues that we're trying to grapple with. But what's happening in practice is that the example that Stacey's talked through about the new requirements for cafes and restaurants are going to be introduced through, I would guess, the next emergency direction of the Deputy Chief Health Officer, whereas usually you would have a multi-year inquiry, you know, that you may send it to the Law Reform Commission or something to work through these extraordinary complex legal and social policy issues. And I think we're seeing this across so many different aspects of the pandemic response. And I've started to think that in the term of pandemic preparedness, which we ordinarily think about in terms of really important practical things like what's in the national medical stockpile, but I think also perhaps something that we might learn from this is what does legal preparedness for a pandemic look like. So Stacey, last one before we go to the question.
I just think that Mark's formulation there of expectation is really a useful concept to help think about this, because when you think about a cafe, hey, they've got my phone number and my name to take a booking, right? Surely that's okay. That's not going to be a problem. But, you know, Jonathan, as you and I've discussed, what about potentially people coming in, posing as someone else, someone who really didn't want them to know that they were there, like in a family violence type situation? People who have never, as Mark said, turned their minds to these privacy issues and handing information over are not going to say, oh, hang on a minute, I don't know who this person is. I'm not going to hand it over until I get your ID. Someone comes in official looking, you know, I need this information. Who knows what might get handed over? And that goes back to Mark's, you know, concept of what do people expect the information to be used for, and then what is the misuse it could be put to that we don't normally turn our minds to because we don't expect it to be used that way.
I promise to be ruthless. Jeannie, last comment.
Oh, I was just going to say, but reasonable expectations are also shaped by information available. It's very hard to ask individual consumers to assess risks when they have no experience of those risks. Now, when we have the doctor-patient relationship that I think Mark was talking about earlier, that's a very close interpersonal relationship with the long history. We understand a lot about that relationship, but what we're being asked to move into now, both with the advent of new technologies and the role that technology is playing in this new COVID post-pandemic world, is we're moving into different types of relationships where we don't understand the scope of those relationships. It's very hard for us to form expectations of what should happen when we don't actually know what's being collected, what can be done with it, or where that might go in the future. So it's not a one-way street. It's a bilateral conversation, effectively.
And across this is this idea that we're all in this together. And I think we've discussed in many different contexts that we're not all in it together, that we're all experiencing it in different ways. But I think that whole messaging of we're all in it together suggests a degree of trust in others that may not always be borne out. So I will get to the first question, which I think is great. So does the panel think that the public's expectations of privacy may be permanently changed, and we have in brackets lowered by the pandemic? So who's going to take, we'll go around, who's going to take that first?
Can I say, I think it's too soon to tell myself. At least I can't tell now. And I think we're in a situation which is still an emergency, but we are going to move out of that at some stage. And then that's when I would want to be looking and thinking about those questions. I hope not. Stacey, and then Mark, and Jeannie, I'll come to you after Mark.
I think Megan's right in the sense that it might be lowered in some ways and then increased in others. So for example, take a look at what's happening in the United States at the moment, where they do not have a federal privacy act. Suddenly, even the Republicans who were seen, this is a generalization, as maybe not wanting such federal legislation, are now putting up legislation around COVID-19 that has a really big privacy, anti-surveillance perspective. And so people's drivers for maybe what they were thinking about privacy might have changed a little bit in the immediate response to the pandemic. And, you know, we may actually see the US, you know, probably not this year, but, you know, certainly move closer to federal legislation that was really not a prospect at all, perhaps before the COVID-19 situation. So people's, you know, may be lowered in some ways, but increased in others.
Mark?
Fundamentally, I'd agree with Megan. It's too early to tell. But what I would want to do is to separate out what we expect and a reasonable expectation. So separate out what we expect and what we have reason to accept as reasonable. Because if this just becomes normal, if it becomes normalized, we may come to expect it. That doesn't necessarily mean it's reasonable. So we have to continue to be willing to challenge what is happening, even if it becomes normalized to the point at which we expect it, so that we can continue to ask whether or not it is a reasonable expectation. And their engagement and participation is key to testing the check and the challenge of any particular trade-off across time. And we shouldn't accept that just because there's a privacy intrusion today that we think is justified, it will also be justified tomorrow. Erosion of privacy is not coastal erosion. We're not talking about a natural phenomenon here. It's a human choice. And we can, if we wish to, stand Canute-like on the sand and turn back that tide, because it's all about what we choose to allow and permit within our society. So it's not inevitable, and we shouldn't assume that just because we come to expect it, that it's a reasonable expectation.
Jeannie?
I'm going to do a little dance of applause for Mark's comments and those of Megan and Stacey. The only thing I would add here is we've talked a lot about the front-end design of, say, the app. I think this conversation also reminds us about the back-end design, the governance mechanisms that go back and check what's being done with the data that's collected and what's being done once the pandemic comes to an end.
Okay, the next question, which is going to be hard to answer, is does the COVID Safe app strike the right balance between privacy and public health? And while you're thinking about how to answer that, I might come back to, I thought one of the really important points that Mark made at the outset was that although there's often this idea that it's privacy versus public health, that the two are necessarily in tension. I think Mark's point is that done well, they can actually be mutually reinforcing. But so do people have any, I think similarly to Megan's first answer to the last question. It's a bit early to tell. But how do you imagine us over time coming to a collective understanding of whether it got the balance right or not? Jeannie?
Oh, okay. I was going to say, I think it's early to tell, but I think that goes to some of the government mechanisms that sit around the app. From what I can gather by listening to conversations that are happening in the media and Twitter and the like, it's not terrible if you assess it by terms of safety and data protection, and it's not terrible if you assess it in terms of collecting information that will be useful for epidemiological studies. It's not bad, it's not perfect. So I think, again, I'll come back to that point. We don't just set something up and then leave it to run. We go back and we check it, and we reassess it, and we tweak it. So my point would be, we need to keep looking at it to make sure that we get that balance as right as we can make it. Mark.
Megan? Oh,
Sorry,
Megan, go.
Can I? I just wanted to add one thing here about the coming back to the point that Jeannie's made earlier. I think one of my concerns about the app is not actually about the way the app works, which I think there has been a lot of effort to, although I know that there are also a lot of kind of concerns that are being raised. But it's also access to it. I mean, do the people who are really most at risk have this app? Can they even work out the technology to get it? Do they even have a mobile phone? And so on, those questions. So, I mean, if we really want everyone to have access to it, should we be sending mobile phones with the app downloaded on it to the people who are most at risk, or providing them with it, rather than just saying, you look after that side of it?
Mark?
Is the end goal a shared one? Is the trade-off a fair one? The end goal would appear to be a shared one. Is the trade-off a fair one? Or do people perceive it to be? Are they downloading it? So is the trade-off the one that's currently struck the right one? I think an indication of that, or at least public perception of that, is people voting with their feet. Is it being downloaded? But I also want to support Jeannie's point, because the OECD recommendation on health data governance have as one of the core principles monitoring, evaluation. We need to know whether or not the intended benefits are being achieved. We need to know whether there are any unanticipated negative consequences. It's only through that kind of monitoring and evaluation that you can really determine, with the benefit of hindsight, whether or not the trade-off really was a fair one or not.
And I suspect much in the end will depend on how many COVID cases we have. So at the moment, there's this sense that Australia is doing really well, and we're starting to ease restrictions, and we're hoping that that will continue. And I suspect that the questions about how much did the COVID Safe app actually contribute to how we did will only be followed by a small number of people. And instead, I think there'll be gut responses to whether we came out of it well, and whether the government or governments were seen to have done a good job. And at least so far, the app has been marketed as such a critical part of what we're doing that the judgments that we make might not actually relate to the evidence possibility. I'm looking, we're going to, we've got another one. Sorry, there's one that's just come through now. And we're going to have to do this one quickly. As health services move to online due to COVID-19, and there's an increased use of telehealth, does this change how we protect our private information and details we share with our GPs? And that's a complex one. I might go to Mark.
Well, it may change practices, because the way in which we maintain security may need to change, but it won't change the principles.
So I guess inherent in that is, and that'd be a really interesting research question, is are people any less likely to be disclosing information to their GPs through a telehealth appointment than they would be if they were inside the office. Stacey, you, I'm taking your smile as wanting to comment.
I think it would be an interesting research question, because I think the answer is it depends, and therefore it takes a PhD to fill in the gaps between the question and the it depends answer. But, you know, from what I've experienced, there are people on the spectrum of, I'm never downloading an app, I don't want people having my information, it's not happening, to a lot of other people now where if the app's convenient enough, and, you know, Mark mentioned justifications and rationales before, they'll download basically anything and use basically anything. And they will also link things together. So you might link your supermarket loyalty card with your insurance card, and then you'll get extra points because you've bought healthy this week, or whatever it might be. Suddenly all these different people, your credit card holder has a huge amount of information about you. So a lot of people actually, they get the app and they kind of forget, as Jeannie said, what goes on behind and what's being shared and where it's all going. And you do that with your web searches too. You know, Google Analytics is in the background potentially telling people where you've been, but I want to get to that website and it's convenient and I'll do it. And for some people, and we mentioned this before about people experiencing things equally, having access to something online by way of an app when you're in remote Australia or something like that, for example, is going to be incredibly important. And then just bring it back to the private sector quickly. The other thing that we're seeing internationally is companies develop their own apps. And so it's not just maybe giving your health information to a health provider who is actually regulated and needs to look after it in accordance with the health regulations. In some jurisdictions, you're giving up your temperature, etc., to the government every day, but companies in some places are actually getting you to input your temperature in the morning. That then gets collected, and or you just might be a yes or no, you know, whether you've met a threshold, and unless you have the OK button on your app, don't come to work. So suddenly you've got companies now doing what that question really speaks to in terms of sharing information.
Jeannie?
Oh, I was just going to say, and this is moving a little bit away from the doctor-patient GP relationship, is that what Stacey's talking about, which is the effectively the on-selling of data, just reminds us that we need stronger data protection laws, because Stacey's point was, well, people don't know this is happening or they don't know how to stop it. Actually, if you survey people, there's actually quite a lot of people who do know it's happening but don't know how to stop it, and are concerned about it but don't know how to stop it. Now, what we don't want to do is have to responsibilise the individual. There actually should be a structural response to this. I think this is part of what's we talk about when we talk about privacy by design, that the default measure should be that this doesn't happen, not that the individual has to take measure to stop it happening.
Okay, we could go on for hours, but we're running out of time. So I'm going to go around for really, really quick final comments. Megan first.
I put my hand up a lot about that. So final comment. I'm not sure where I end up on this. I'm just waiting to see. I'm really interested.
But there's something new. There's something that feels different that's happening, and we don't know how it's going to play out. That's exactly right. Mark?
I just think it's important we recognise it's not always going to play out the same way for everyone. To go back to your point, so even if we fall back on notions such as reasonable expectation, what is reasonable isn't necessarily going to be the same for everyone in all the different circumstances. So as we look to transition out of the current situation, we should be prepared to accommodate the needs of those that have different reasonable expectations and a different place with regards to what they have reason to accept in different circumstances. So we can't be simplistic about this.
Stacey and then Jeannie.
I think for me, maybe it's just the reality of the daily grind, trying to figure some of these issues out in real time, is just how much work there is still to be done in this space. And we have a review of the Privacy Act here in Australia. We've had regulators in Europe under the General Data Protection Regulation, which is supposed to cover everyone in Europe, come out with different views depending on which country they're in. So it just highlights how much work there is still to be done in the area, and how much more scope there is, I think, to try and get some harmonisation between these different types of legislations, whether it be between states or whether it be between countries, so that actually also as an international community, because we haven't spoken too much about that today, we can really move forward in privacy, protecting people so that they can share information in a safe way.
And final word to Jeannie.
Well, I've enjoyed listening to all my co-panelists, and my final word would be, in all of these conversations, as I think is coming out of Mark's comment, we need to remember the issues of digital poverty and digital equity.
All right. Well, thank you so much. So fantastic panel, fantastic panelists. Round of applause.
And you too, Jonathan. You've been
Thank you.
marvellous.
Thank you, Jonathan.
In the hot seat.